the man, the myth, the legend, Ron Coleman. How's it going, buddy?
You know, I always hear about that. People always call me the legendary Ron Coleman. I don't know what this legend is. What's the legend?
It's the person that you never lose. You never lose.
So let's get that. Any lawyer who tells you he never loses is a lawyer who never tries cases.
Fair.
There's so much for us to clear up here. So I mean, I'm looking at the comments,
mm-hmm.
and someone says, I'm worried about Play Lunar. I'm worried about this judge you got. This shouldn't have even got this far. Dude. The problem isn't with the judge. This judge missed nothing. This judge gave us a very, very good decision. What happened, however, is that all the judges of history before her created a body of law. It's called the common law. It's called precedent. And one of the precedents that she is obligated to follow is that when there is a jurisdictional issue, that it is appropriate in most cases to allow a certain amount of what's called jurisdictional discovery. That's what's going on here. In other words, everything in the opinion was pretty good for us. But what the judge did say was, well, but, I might not have jurisdiction over this case. It probably really should be in California, which we argued.
Mm-hmm.
We argued. Oh, and by the way, I want to say hi to my adversaries, who I know if they're not watching, they're having someone from their office watch, because they're obsessed with you, Jeff. And I think they kind of like you.
I don't know how to feel about that.
Well, there's not anything wrong with that, Jeff. With your not knowing how to feel. That in a discovery dispute like this, a reply submission is unusual.
What is a reply submission?
Okay. So anytime you ask a judge to do something, and this is true whether it's a motion or on an appeal. I want you judges on the appeal court. Anytime you ask a court to do something, you have the burden of moving the ball from where you are to where you want to go.
Mm-hmm.
So you have to first come forward with your argument, and as the case may be, with your evidence. And then the other side says, no, here's why Coleman's wrong. And then because the burden is on me, I get last licks. I always get to say the last thing.
Mm-hmm.
So on an appeal or on a motion, it's moving brief or moving submission. In other words, this is how I'm going to start the process of arguing. Give me something I want. Other side says, no, he's full of it. I get one last shot at saying, no, here's why I'm not full of it.
Okay.
In discovery disputes, though, the general rule is each side, it's not a motion. It's really, we're asking the judge to sort something out, and you don't usually have a reply. But these guys are super, super aggressive, and they asked me would I consent, because I asked for an extension of time because I needed it. And they said, well, we'll give you an extension of time on condition that you will consent to our request for a reply brief, which the court has to grant us. But if you consent to it, we're much more likely to get it. The rules are technical crap. Don't worry about it.
Okay.
So they filed their reply last night. And the general rule is, like, say a typical motion, I get 40 pages to argue. Here's why the court should do what I want. And then the other side says get 40 pages to say, here's why Coleman should pound sand. And then on the reply brief, usually it's like 15 pages. In other words, reply brief is your chance to just sort of touch up. No, you see, they misconstrued what I said. Their reply is longer than their original submission.
Which is rare.
It's rare, and as a general rule, judges don't like it.
Okay.
Because it almost certainly means that one side or the other, or that the side that's adding to the reply is adding something new. Now, what I would now listen. One of the really bush league things that these guys do is, besides monitoring your entire life, so one of the things these guys do is like they like to run to the court with things I said on streams. And, I'm not going to, in a case
you're not part of the lawsuit though. That has no bearing on anything whatsoever.
Well, what they would like the judge to think is that I'm exchanging, that I'm waiving attorney-client privilege, or that I mean, like you said, that the whole thing with meme, why should that have been in there at all? That was just to get the judge to not like me. What that really does, and by the way, these are not bad lawyers. I mean, in other words, their technical skills are excellent. The lawsuit itself is meritless, utterly meritless.
I don't.
Okay, but can I just tell you that there are a lot of people who can buy and sell me, and even you, okay, who have made a living off meritless lawsuits. I mean, that's.
Let me ask you that actually while we're on that topic. What at this point am I being sued for? Because I'm not. Like seriously, like don't you think? Even before jurisdiction, even before it gets to that point, shouldn't that supersede jurisdiction? Shouldn't the judge be like,
oh my goodness. No, it doesn't.
That's crazy.
No, it's not crazy. The court should not even have the ability to weigh in on whether or not you did something unlawful if it has no jurisdiction over you.
I guess, yeah, true.
But here's the thing. It goes back to what I said in some of my introductory remarks about precedent and the rules. The law does provide the judge with the option of dismissing a case where jurisdiction does not appear to be present. She took the softer option, which was to give them jurisdictional discovery.
Which you said that's typically what they do. That is
look, if a judge really thinks it doesn't fly, but I think what the judge was acknowledging here, I'll let you guys in on something. Very, very few judges understand our world. When I say our world, I mean the YouTube world. I mean, of course, Ron Coleman, live in many, many worlds, but this world of streaming, very few judges and lawyers, and certainly old ones like me. So what I think may have been the case here is that the judge said, I don't really know this stuff. I mean, maybe they're right. Maybe we're going to find. In other words, I think anyone watching, anyone who, like your listeners, I think it's really obvious if you understand the scene and understand this particular show. You have, like, we all have our circles of friends. Just like I do a regular show with Valiant Renegade, and I frequently appear on WDW Pro. So like I'm part of that cluster. I've got friends over there, and I might be, but I'm not in business with them in any possible way.
Right.
Although actually they happen to be my clients, but that's a completely separate. I think if the judge got that the way everyone listening to the sound of my voice, including my adversaries who are watching this right now, either live or recorded, love you guys, really. You're courteous and professional. And last couple of submissions, actually, I think you really kind of
pushed it
a little bit. And I don't know if that came across at all in my letter, but in any event, she doesn't, and her clerks don't. And she said, listen, maybe there's going to be some smoking gun that is going to demonstrate that Smash is really in business with Toasty.
But fair. But let me interrupt you and ask you this then. They have zero evidence or proof of that. They provided nothing.
Right.
And they demanded to the judge, they said, this guy's doing all these bad things to us. Let us prove it to you so that we can dive into everything that he's doing to prove it. That's not how a court case should ever work, to be able to just accuse someone, to be able to get access to their private information.
Well, that's a very well-known and legitimate complaint. The American rules regarding discovery are really extreme. And in many other countries, including semi-civilized countries like in Western Europe, they sneer at our discovery rules. They flare their nostrils and fart in our general direction. They think it's really out of line how much information, how much adversaries in litigation are allowed to go through the underwear drawers, and also to publicize information. But it is what it is, and it sucks. It sucks that someone can, because what you're seeing is a miniature version. This is just the jurisdictional stuff. Mm-hmm. I try not to bog down discovery with a lot of over-designation of stuff as confidential. And I expect my adversaries to respect that, but sometimes they don't. So in other words, I could have redacted your personal email address. Mm-hmm. Frankly, first of all, I would have had to find it. You think I watched that 2 hours?
How long? That was about 2 hours of footage, right? That was or an hour of footage.
Yeah. And frankly, you don't want to pay me for that. Okay. No. And I wouldn't, and that would be double time, by the way. So I said, it is what it is. Because what's my concern? See, the judge has basically ordered that it all has to be given. And I think that I think she's made a mistake. In other words, I argued a letter ago, I said, I don't think, remember, this is the magistrate judge who's the traffic cop. Mm-hmm. Judge Ashkenazi is, I think really she may be a Khazar, but I don't know. She is in charge of managing discovery disputes. Now, it's in the Eastern District of New York. Okay, that's like Brooklyn, Long Island, Queens. It's the outer boroughs, New York City, and Long Island. In the Eastern District of New York, they use magistrates a lot. In contrast, in Manhattan, the Southern District of New York, most of the Article 3 judges, the presidentially appointed judges, are not. They're hands-on, and they tend to not use magistrates as much. Interestingly enough, here as is consistent with the practice in the Eastern District, the judge who I think we did very well with on the substantive ruling, handed off discovery to Judge Ashkenazi, who might have a different take on the case, but she's reading the way she reads the judge's jurisdictional discovery ruling was produce whatever would be necessary to demonstrate the extent of the connection between you and the three friends of yours.
But I feel like that sets me up to fail because that's so ambiguous. It's like, just give us things to prove that you're connected to him. I'm like, well, I'm not. So what the fuck do I give you?
Well, you're bringing up the valid point, which is that it is difficult to prove a negative.
Right.
But that's why I have been so eager to produce as much as possible that doesn't get too personal and too gross, which turns out that you have no life, so there's really not even any of that.
Right.
So there's the risk that people are going to post stuff that and people are going to go through it. And I've made, I don't think, frankly, that the rule regarding what gets produced in discovery versus what is publicly accessible, they're not the same. In other words, there's no reason all the stuff that you produce doesn't necessarily get into the public record at all, unless it's part of a motion. I argue that, Judge, you don't really think that every single conversation between them is relevant to the issue of jurisdiction, do you? And I suppose the answer to that could be, well, if they're talking about, anyway, it's great that we're doing business together and that you're using my New York address. Like, in other words, but then if those were the conversations, then we would produce those because they would be responsive. But the idea that, so what are you watching these days? You going, or where you going for the weekend? Crap like that.
Or what game are you playing, or do you want to play a game later, or something like that? That's not.
But again, on the other hand, if I can say I gave them the whole freaking conversation,
and there was nothing.
So where we are now is the disclosure period, and when the disclosure period is over, then they're going to come back to the judge and say, okay, here's what we've got on the jurisdictional discovery. Unless they have the balls, to actually acknowledge that, we've looked at this and there isn't really a bona fide basis for asserting the jurisdiction of the Eastern District of New York over JT. I would love to know whether they're doing it entirely pro bono. I think it's pretty clear that your adversary does not have the money to pay for
three lawyers,
all these lawyers doing all this work. And
unless he's being sponsored by somebody,
right, because then there definitely are candidates for that. Mm-hmm. Some of them might be in the chat right now. Mm-hmm. Mm-hmm. So that's the story, guys. That's what's going on here. You got to stop. You got to listen. I understand it's entertaining, and I understand that you love Jeff. What's not to love?
I guess that depends on who you ask.
I mean, among stochastic terrorists, they don't come better. But I mean, last night I filed your letter, and it was why was it filed late at night? Well, first of all, yeah, it turned out to be a lot more there than I thought there was. Like, that's always the case when you have ADHD. Mm-hmm. You get into some bad habits because you can get things done really late and really fast. But also, the more I looked into it, the more I said, "Wow, there's really strong case law on this." And also, I had other things to do during the day, so back off. Mm-hmm. But I got it, and yesterday wasn't even a real day, right? It was milk day. But nonetheless, I filed it, and then I think it was last night or first thing this morning, one of your fans, breaking story, had screenshots of each page of my brilliant.
I saw that, yeah.
I'm thinking, this is about it. I mean, my litigation for Gavin McInnes doesn't get nearly this much attention, and that's been going on for 6 years now. But in any event, I get that and that's why I agreed. I agree. That's why I said it would be good for me to come on tonight, and I could even take questions from the chat if you want.
Yeah, that'd be great.
One of the things that this lawsuit was meant to achieve was to intimidate people like you so that you would stop
covering or doing anything or saying anything,
hurting the feelings of their client. Let
me ask you from a legal standpoint, is there anything illegal about hurting the feelings of someone?
In and of itself, usually not.
Okay.
But if you establish a tort, a legal wrong, let's say defamation, then hurt feelings are if you're seeking damages based on emotional damages, which I refuse to ever let my clients do, and be clear, there are many cases where that is an entirely appropriate measure of damages, but I'm mostly a business litigator, and emotional, like if you haven't got real damages, like money damages, then I know that you probably can't pay me. But it also means I'm not going to be able to prove like once you put emotional damages into your case, your entire mental and emotional and psychological life becomes my bitch. Okay, if I'm the other side, so you don't want that. So yeah, the hurting. It is legal to hurt people's feelings. I do it all day long on X.
Yep.
But there is a point at which that can be illegal if it's defamatory or if it's harassing. It can be, and she's claiming that it is. She's incorrect.
Well, how about this one? Dave Viper, can you anti-SLAPP over jurisdiction since it's so clear it's not in jurisdiction? They're clearly here to waste time and money. That's a really good question. Is there something we can recover the cost of for anti-SLAPP?
Well, okay, so the question really is whether New York's anti-SLAPP law would apply if their jurisdictional argument ends up being what the case is dismissed on, rather than the merits. And I don't want to comment on that now because that's an issue that I think is going to end up being litigated. But I will say this much: I'm going to be seeking anti-SLAPP damages, and if that is the way we end up finding out who paid for this lawsuit, which is possible, then that'll be all that more enjoyable.
I think that'd be fascinating. I really do.
I think so.
Question. So she wants Hypnotic's info and legally dox them. Is this even legal? Because he has nothing to do with it at all.
Wait a minute. Is it them or is it he?
He.
This is not the kind of YouTube channel where I expect a lot of them shit, okay? No, it's not legal but I would have to, in order to get sanctions for that, I would have to demonstrate that the only reason to get Hypnotic's info was to dox him. And that's a really hard argument to make when they are pinning they claim that he's really in New York.
Right.
They claim that, and by the way, even if they demonstrated that
doesn't mean anything.
Yeah. Even if there were even if you were sharing revenue with them, with Hypnotic, and he did live in
it, still doesn't prove anything. Like they have another step they have to go beyond it.
Yeah, I mean it's really grasping at straws, and I'm disappointed that the magistrate has been so.
Because you think they would think that. They would think, okay, so if they're going to get this address as proof of he's in cahoots with this guy, does that alone prove anything? No, it doesn't. So why is that address so important?
Well,
they need to cooperate.
Right, but in there, look, you're talking about people who are very optimistic, okay, and who are they are cause people. They are Kool-Aid drinkers. Like you and I are, okay? We believe in our causes. We're committed to them. We believe in right and wrong, and they believe in their campaign. Look at the name of the law, Fem Law. I mean, this is what they're about. Yep. So they are optimistic. You have to be optimistic really to be in this business. And they say, if I can cross that bridge, I betcha I can prove because look, here's the thing: you and I and Hypnotic know. You don't live in New York, and you're not in business with him. But they don't really know that. They think they now. why you would want to go through all this trouble. In other words, you could just as well have decided to litigate this in New York. Like, California is not a friendlier. Anti-SLAPP was invented in California,
Right.
and the judges are not shy about it there. But I guess the lawyers are here, and they really want to handle it here. And of course, the plaintiff is here.
Right. Right. But I'm not.
But the answer to your question, though, it's a damn good question, is they think they don't know what you and I know, and they believe that there's a smoking gun, or at least enough of a smoking gun that they can convince the judge that if you let us continue with the case, we're going to find even more. Now, the problem with that reasoning is, if they don't find even more, then you will have litigated for 18 months.
And have nothing except a lot of bills.
No, but not. Well, you make that sound like a bad thing. But
well, I'm not the one getting paid.
That makes two of us at this point, folks. No, but the point is, it's worse than that. It's that you will have been litigating for 18 months in a case over which the court has no jurisdiction. You shouldn't have had to disclose any of your confidential information, any of your private stuff. But
what Joe said here, he says, isn't the burden to prove Hypno lives in New York on them? Why should I have to disprove their? Why am I needing to provide information?
Okay, so let us not confuse the difference between the burden of proof and the rules governing civil discovery. Look, remember I was saying before how the Europeans sneer at our. What that means is you could be a company that is selling candy made out of rat brains, okay? Mm-hmm. And let's say it's against the law. And
in New York, that's questionable, but yeah.
And all day long, you're sending emails, and and everyone in the company is like laughing about it, and they're texting each other. And then so this is disgusting. I'm gonna sue them. My kid got sick. If you don't have one of those emails yourself, you can't win, because you're never going to get the truth.
Well, how about this one? Jay Viper brings up something like
Jay again.
Yes, this is something I meant to bring up to you. Is the issue of Lane, her lawyer, publicly promoting doxing going to ever be brought up? They've already used this.
Yeah. So I spoke to one of his colleagues about that tweet, and I got to tell you guys, you sometimes this is a real problem. And it's a problem. It's ironic. The plaintiff in this case wants to take a lot of stuff that has been said on the internet out of the context that it was said, mm-hmm. in order to prove, defamation. At the same time, normal people, not lawyers, normal intelligent people say, "How about this tweet?" You have to look at the place where that tweet fits into the conversation that was taking place there. It's not an admission that what we do is get discovery in order to dox people. It was a tongue-in-cheek. It was someone had already accused someone of doxing and said, "Oh no, I'll decide who's going to be doxed." Like, it's a fucking joke. You're not going to
context matters.
Context matters a lot, especially in defamation, which is why they can't win this case.
Right.
You know what you have to do on the especially on X to get defamation on X. I mean,
it's insane.
You would pretty much have to say that like someone's wife is a man, and that person would have to be like the president of a foreign country.
Well, ironically, you bring that up. She reached out to my wife, and I could argue tried to cause strife in my relationship because she didn't like how I reported on her situation.
Of course she did.
And ironically, Alyssa's suing me. Well, I'm like, I could have a better case against Alyssa than she does against me. Ironically.
If you were a pussy.
Well, that's the thing. That's the thing. Yeah.
Because look, you're in the rough and tumble. I mean, look, it's really out of line. Look, it's a chick move to call someone's house up, and yell at them. What can I tell you? These are. I joke
she
about.
Also challenged the entire internet to a fight physically. Like, that's a real thing. That wasn't out of context. That was like a legitimate, like, you could argue.
But now we're talking about why she's a person that we don't want to be friends with, and why she. But
well, I could also argue she's bringing this upon herself, though.
Yeah, no, and you could, and that's really the essence of our motion to dismiss, which is that look at the things this person says about herself.
Right.
Happy National Slut Day. As a former sex worker myself, sex work is real.
Or cam whore or whatever the fuck she said. Yeah, things like that. I'm just like, or how she slept with a dude for a story. That was a thing too that she said.
All right, but who among us? Come on, Jeff. Who among us?
Well, I guess the point is you're welcome to do it, but don't start suing people for saying, "Hey, she said she did this." That's the problem.
No, but that's why we win the case when all this is over. But in order to screw with your life, that's why this is an anti-SLAPP case. That's why this is a SLAPP case, because since this is such an obviously meritless lawsuit under all existing, legal doctrines and whether it's statutes or common law, there's no case here. So why proceed with it? You think because they are ideologically or economically motivated to make new law in New York, that could be. But the point is, that ain't going to happen. That is right. Even New. And by the way, the New York courts, the New York state courts, have acquitted themselves so poorly over the last 10 years. It used to be a matter of some pride to be a New York lawyer because there was a level of sophistication, and you had some great judges in New York who ended up being Supreme Court judges, justices. The New York judiciary today is a shithole. The way they allowed Trump to be treated, the Michael Cohen, like just political crap. And that's, thank God this is in federal court. Thank God this is in federal court. We got any more?
Anything else? Because I know it's late there. I don't want to keep you all night here, Ron.
It is late for me, especially as a senior citizen. But the fact is, I'm a night owl. I do tend to start late and finish late.
Gotcha.
But I never finish first, ladies.
There you go. Well, let me ask you this. Because I know there's a lot of concern over the Discord thing. Did that come and go, or what are they doing with Discord, and why are they coming for me for information when they could theoretically be subpoenaing Discord and stuff like that? For like, what? I don't know what they're trying to get out of me, because I don't. Unless it's just provide thousands and thousands of pages of documentation of everything I've ever done. Which again, what does that prove? I don't understand.
I don't want to go into that.
Okay.
I won't go into that, but I will just generally tell you that they're on a short leash in terms of the amount of time available to them for jurisdictional discovery. Getting subpoenas responded to by technology companies and social media platforms is not a fast turnaround proposition. They tend to just, as a general rule, like if you try to subpoena Facebook or Twitter, especially Facebook and Google, like they'll usually tell you to fuck off.
Yeah.
And because remember, they own the universe. So if you have to come after them to, and punish them for not complying, a process that could take 6 months, what's the worst thing that can happen to them? They might have to pay some money. Money? They're not like us, okay?
Right.
So I don't know if they're going to get anything by way of a subpoena in the foreseeable future.
And Manikannar over on Kick says, Ron, can you estimate the cost for starting an anti-SLAPP in New York City?
For this case or in general?
I have no idea.
Then the answer would have to be no, I can't. I can tell you, just to be clear, folks, the anti-SLAPP counterclaim or the request. So the law in the Second Circuit, okay? Second Circuit decides how New York law shall be applied in the federal courts to the extent that New York state courts have not ruled, or where there is a federal procedural issue that cannot be decided by the New York state courts. In the Second Circuit and in the New York courts, as I understand it, you don't have to make a special motion or bring a separate action under anti-SLAPP. If you file a motion to dismiss and succeed on a case that the court finds, if you raise it in your motion to dismiss and say, and by the way, Judge, this case is a SLAPP lawsuit, and we want sanctions under anti-SLAPP. The courts have almost, not entirely, but consistently said, if a defamation case is dismissed at the pleading stage, that means that it was an anti-SLAPP, that it was a SLAPP case, and anti-SLAPP sanctions are available. So there's no additional cost. That's already been baked into this case.
But the concern would be if they say it's not jurisdiction but move to California, then anti-SLAPP.
Then we could. Well, it would depend on the basis of. You see, the court also could transfer it. It's a lot of moving parts here.
Okay.
Good question, guys. It's been an incredible simulation of reality. I want to thank you all, and thank you, Jeff. Jeff's a great client, by the way. Sometimes a little bit too good because he listens to me almost all the time. But whatever I tell him, he buys it. Like, it doesn't get better than that. And that's the advantage of having a goy for a client. Because when you have a Jew for a client, he already used Chat GTP, and he's going to tell you what you should say. And it's like, God forbid, and, he looked it up, and no, they're actually, believe me. So this is the best of all possible worlds. Seriously, guys.
I place my trust in you, Ron. But before you go, though, I want to say, first off, thank you. You've been incredible. You really have. And mods, please again share Ron's channel. Guys, go sub, bell to him. He puts out awesome content. You really do. Like, every time I watch your videos, I learn something new every single time, and I genuinely appreciate it.
Well, I'll tell you something fun is that the videos, like the stuff from my podcast, I'm really learning there. I'm having genuine conversations with people, and and it's been great for me as a way to increase my appreciation for people that I had been following for many years. I say to them, hey, you come on the show, and now we're buds, so that's pretty cool.
No, you've been great. Thank you again, Ron. Appreciate you, man. We'll see you.